Lawyers of Reddit, what was the best gotcha moment you ever experienced? Lady got into a minor fender bender with a truck in a casino parking lot. She backed out of a spot into him. My guy said she parked and went inside the casino for a few hours. At her deposition, she testified that she was so hurt she went right home and to a hospital. I asked if she was a frequent visitor of the casino and if she had a rewards card. She was happy to tell me she did, and she had gold status, and showed me the card. I subpoenaed her rewards card's records, and it showed she was playing slots for hours after the accident. Plaintiff had an X-ray of an allegedly broken arm. It seemed off to me, and the dates didn't make sense. I was in-house at an academic medical center. I looked at the case more closely, and discovered the plaintiff was a X-ray tech at another hospital. After that, it was all over. My client's house burned down from an explosion in the fuel oil tank used to heat the house. It was clearly the oil maintenance company's fault, but his homeowner's insurance, from a very reputable company, still refused to pay out, citing a ridiculous technicality in his policy. Essentially, the policy covered damage caused by the oil heater, but they claimed that it was the storage tank that exploded and wasn't part of what was covered. So they deny his claim, which was about 1.2 million. And then I get involved. During a deposition with the claims adjuster, I ask how she came to the conclusion that the storage tank was not a part, or at least connected to, the heater. She states that she relied on her expert witness who was an engineer. Little did she know I had already checked this person's background. He had zero engineering experience or education. As most of you might know, you don't get attorney's fees in most cases. However, when an insurance company denies your claim in bad faith, now you do. Her little admission cost the company about $500K in fees, on top of the original claim for $1.2 million. I was trying to get a restraining order for a woman in DV court from her son's father. We are presenting testimony, and she details a story where he grabbed her arm and slammed it on the tub, breaking her wrist. On cross, I asked the accused if he ever broke my client's wrist on purpose. His response: "Hell yeah, I did. She was 9 months pregnant, about to smoke crack and wouldn't stop. I tried to grab her arm to get the pipe and protect my unborn son. F me." She left that detail out in her conversations with me. I had a former client file for bankruptcy, and in connection with that case, brought an action against his landlord for violating the automatic stay. In order to prove damages, he wanted to show he paid my firm for legal fees in connection with the landlord's pursuit of rent in violation of the stay. So this former client's bankruptcy lawyer serves me a subpoena to show up at the bankruptcy hearing. He didn't ask me any questions prior, but just gave me the gist of what the objective was, that is, verify with the court the time I spent and the cost to his client. The bankruptcy attorney called his client, my former client, to the stand first. He asked him questions related to his hiring my firm to do this, and that as it related to his landlord. Apparently that's not enough. The bankruptcy attorney wants me to verify these facts as well. I get put on the stand, and I'm asked to verify the invoice. I first object to the question as a precaution, since it may be a violation of attorney-client privilege, to answer the question and to cover me for any claim by the bar or my former client. As predicted, the judge overrules and orders me to answer. I review the invoice, answer: "No, this is not my invoice." His attorney: "I don't understand. This is your firm's logo and information, right?" Me: "Yes." His attorney: "And you provided these legal services, right?" Me: "No." A very confused attorney slowly started to put together, after a couple more follow-up questions, that this idiot client of ours had manufactured my invoice to prove his damages. Needless to say, that I could have given his new attorney the heads up, but I wasn't going to help someone who had committed perjury to the court using my name. I had represented him in a completely different matter, and this guy was trying to make some extra cash through this bankruptcy hearing. To lessons: tell your attorney everything, and as an attorney, make sure your client feels comfortable to tell you everything. Cross-examining a custom home builder who had a lump sum contract, set price as opposed to cost plus, which means cost of the materials plus X% as builder fee, with the homeowner. Claimed he put 20% more labor/materials in building the home than the contracted provided for, and he was suing for these excess costs. Was asking him about an email with my client negotiating the price of the construction, and he volunteers that he knew he couldn't build it for that price. My head snaps up, supervising partner's head snaps up, and opposing counsel goes pale. Dialogue was something like, me, you quoted X price? Builder, yes. Me, you knew you couldn't build it for that price? Builder, yes. Me, you knew the homeowner was relying on that quote? Builder, yes. Me, you knew homeowner wouldn't have signed contract without that representation? Builder, yes. Me, and you told homeowner's lender you could do it for X? Builder, yes. Me, and bank relied on that price and wouldn't have given loan if knew it was wrong? Builder, yes. This is textbook fraudulent inducement, and he had no idea. Builder got poured out in the arbitration award and slapped builder with sizable punitive damages on top of it. 5 minutes of testimony sunk his case because he volunteered information without being prompted. Plaintiff alleged he was so injured in an auto accident that he couldn't work, do any regular activities, or pick up his young kids. He then posted on his public Facebook profile him doing the ice bucket challenge. If you're not familiar, he basically lifted a huge cooler filled with ice water over his head. His attorney had no idea he had posted it. Not so much a gotcha as it is the defendant giving themselves up. When I worked for insurance defense, I handled a fraud case where a man reported his Rolex as being stolen. He was adamant that he was at a hotel and it was stolen. He has shown no proof of being in a hotel, so it's flagged. We go through the whole process and finally reach depositions. He gets sworn in and eventually let out that he wasn't at a hotel, but rather with his mistress, and he had left it at her house. His wife noticed he didn't have it on, so he immediately claims it must have been stolen, etc. This man decided to hire an attorney and go through this whole circus just so his wife wouldn't find out about his affair. Needless to say, the claim was denied. Not a lawyer, but when I was in the military I was accused of something I didn't do, and I had to go to court over it. And during court the prosecutor started to detail this investigation and how they had staked my apartment out for months. They entered into evidence a picture of my apartment, and when they put it up I looked shocked at my lawyer because it wasn't a picture of my place. It was my ex-wife's apartment, a place I had never lived, never even spent a single night there. I lived in a house, she lived in an apartment. And when my lawyer was asked if she objected to the picture being entered into evidence, she replied, I don't mind them entering it into evidence as long as they change the listing of it. And when one of the members of the panel, no judge, 3-member board, asked what was wrong with the listing, she looked at him and said that's not his apartment. On top of this, the witness they used against me described going to my house on the night in question, and she named the subdivision where she had visited me, except that wasn't where I lived either. Also wasn't where the picture they had was either. Case was dismissed, and I was told they requested the witness to return to answer questions about perjury. Had a client accused of leading the cops on a high-speed chase. The cop on the stand estimated he was going 90 miles per hour, but never actually clocked him. Then the cop identified where the chase started with me and where it ended. It lasted about 2 miles. Then we went through his log of when it started and when it ended. About 3.5 minutes. Once you walk through the math on that, the average speed of this chase was 35 miles per hour. Client got acquitted really quickly after that. The first case I ever did, opposing counsel misplaced the copy of my client's driver's license. Rather than admitting his mistake and asking me to resend it, he filed a motion to compel, claiming we never sent it. Well, I was able to provide proof that we'd sent it to him like 8 months ago, so the judge was rather displeased with his antics. Represented a DUI client who swore up and down to me he hadn't been drinking or doing any drugs. Newbie officer who had his field training officer with him in the car. Rookie pulls client over for attack violation, walks back to the car with body camera still on. Training officer says, get him out for a DUI, and the rookie says, but he's not intoxicated, to which the reply was, do it anyway. Body cam clicks off, turns on 7 minutes later, and they're doing field sobriety exercises on my client. Client sat in custody for 3 weeks until I finally got the tape from the prosecutor and presented it to the judge. The oh shit looks from the prosecutor and FTO when the judge saw the tape. I'll treasure that one. Judge wrote the police chief a letter saying the FTO was dead to him, and he'd deny every search warrant he tried to bring thereafter for being a liar. Client is hopefully still on track with his civil attorney in a lawsuit. I was suing a landlord who failed to make serious repairs in order to force the tenant out. The hard part is proving bad intent instead of mere idiocy, so you get higher damages. Code enforcement was involved, so I request those records. The landlord left a voicemail to the enforcement department saying to hold off on the fines. They will make the repairs as soon as the tenant is forced out. That was an easy case. That's it for today. Do all the YouTube things. Just so you all know, I do read all the comments, and as usual I'll hang around this comment section for the first hour after this video goes up.